Hello everyone and welcome back to school. Let's go ahead and get started. Students, come on in. Please take your seats. Thank you very much. Go ahead and get settled. Good job, good job. Thank you. Son, go ahead and have your seat.
Yes, sir.
Thank you. All right, now our first lesson today is to get to know the different laws that are associated with the U.S. workforce, starting with the Civil Rights Act of 1964. All right. Now the Civil Rights Act of 1964 outlaws discrimination based on race, color, religion, sex, or national origin. It prohibits unequal application of voter registration requirements, racial segregation in schools, employment, and public accommodations. So the key point here is it outlaws discrimination. So if you're discriminating against any of your employees, you could be held liable, okay? Young man over there, please don't lick the wall, okay? Don't do that.
Aww.
Okay, then there's the Fair Labor Standards Act, or FLSA, that establishes minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector and in federal, state, and local governments. Covered non-exempt workers are entitled to a minimum wage of no less than $7.25 per hour effective July 24, 2009. However, some states may have a different minimum wage that supersedes the federal minimum wage, or in other words, employees may be entitled to a higher minimum wage based on each state. Now class, I suggest Googling your state's minimum wage to get to know the exact amount.
Did you know bees smell fear?
Now, in addition, employees covered by the Fair Labor Standards Act must receive overtime pay for employees who work over 40 hours in a work week at a rate not less than time and 1/2 their regular rates of pay. Now, there is no limit on the number of hours employees 16 years or older may work in any given work week. The FLSA does not require overtime pay for work on weekends, holidays, or regular days of rest unless overtime is worked on such days. Okay, so important to remember that. If the employee is younger than 16 years of age, there is a limit on how long they can work. So I recommend going to the Youth Rules website for more information. And at this website, you can quickly access information about federal and state labor laws that apply to young workers. The website educates teens on the rules and provides information for parents, educators, and employers. Okay, young man, just because your finger fits in your nose doesn't mean you should put it there, okay? So just take it out. Okay. Then there is the Family Medical Leave Act. The FMLA Act provides certain employees with up to 12 weeks of unpaid, job-protected leave, and that's per year. It also requires that their group health benefits be maintained during that leave. Okay, so FMLA is designed to help employees balance their work and family responsibilities by allowing them to take reasonable unpaid leave for certain family and medical reasons. So for example, taking a parent who has cancer and needs routine doctor visits, that would be a good example. Now, Section 101 of FMLA defines a serious health condition as an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care facility, or continuing treatment by a healthcare provider. So FMLA also seeks to accommodate the legitimate interest of employers and promote equal employment opportunity for men and women. FMLA applies to all public agencies, all public and private elementary and secondary schools, and companies with 50 or more employees. Now, these employers must provide an eligible employee with up to 12 weeks of unpaid leave each year for any of the following reasons: for the birth and care of a newborn child of an employee, for placement with the employee of a child for adoption or foster care, to care for an immediate family member such as a spouse, child, or parent who has a serious health condition, or to take medical leave when the employee is unable to work because of a serious health condition. Also, it includes employees who are eligible for leave if they have worked for their employer in the last 12 months and for at least 1,250 hours over the past 12 months, and work at a location where the company employs 50 or more employees within 75 miles. Excuse me, young man. Do not disturb the reading group unless you're bleeding, vomiting, or on fire. Okay? Do not disturb them. Thank you.
My pants are on backwards.
Next, we have the Americans with Disabilities Act, or ADA. ADA is a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places that are open to the general public. The purpose of the ADA Act is to make sure that people with disabilities have the same rights and opportunities as everyone else. The ADA gives civil rights protections to individuals with disabilities similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion. It guarantees equal opportunity for individuals with disabilities in public accommodations, employment, transportation, state and local government services, and telecommunications. Accommodations can allow an employee to become successful in the workplace. They can also put into place to help overcome any barrier an employee may be experiencing. Young man, you know you did a great job putting on your belt. Now go back in the bathroom and turn your pants around. Okay? Good job. Thank you.
You're welcome, Mr. Dutch.
Now, the Pregnancy Discrimination Act prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions. The pregnancy must be deemed as a normal, objectifiable condition for that to be enacted. Employers with less than 15 employees are exempted from the Pregnancy Discrimination Act. Employers are exempt from providing medical coverage for an elective abortion unless the mother's life is threatened. And no, you cannot ask if a woman is pregnant during an interview, so please do not do that. All right, now whoever's making those rude body noises, please stop, okay? Thank you. Now moving on, the Age Discrimination in Employment Act, or ADEA, protects certain applicants and employees 40 years of age and older from discrimination on the basis of age in hiring, promotion, discharge, compensation or terms, conditions or privileges of employment. The ADEA prohibits discrimination on the basis of age in programs and activities receiving federal financial assistance. The Act, which applies to all ages, permits the use of certain age distinctions and factors other than age that meet the Act's requirements. Okay, young man, is this your booger on my arm? Now, there are other laws to be aware of, but these are the main 6 you should understand. Again, this is just an overview, and to learn more about specific laws in your state, please refer to your state's government website. This is where you'll likely find some information on the Equal Employment Opportunity Commission, or EEOC. Now, the EEOC is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of a person's race, color, religion, sex, and that includes pregnancy, gender identity, sexual orientation, and national origin, age, disability, genetic information, and retaliation after a complaint. So EEOC kind of makes sure that we're all doing everything we're supposed to be doing. Now, I'm going to go ahead and put you guys to the test. I'm going to give you a scenario, and you tell me if you think the company is discriminating against the individual based on any of these laws that I've mentioned.